Students, welcome to AKS IAS. In this video, we'll be discussing about the autonomy of tribunals. So, the context for us discussing this issue is recently the central government has changed the rules pertaining to the appointment and service conditions of people working in the tribunals. So, in this context, we'll be discussing about what are the implications that these new rules are going to have, whether these rules are actually an improvement over the previous rules of 2017, and what could be the possible limitations and possible suggestions for the overall improvement to so as to safeguard the autonomy of the tribunals. So recently, the Union Ministry of Finance framed a new set of rules called the Tribunals, Appellate Tribunal, and other authorities, qualifications, experience, and other conditions of service of the Members' Rules 2020 that prescribe uniform norms. So, these rules prescribe uniform norms for the appointment as well as the service conditions of various members to the tribunals. The new rules have been framed by the government as the previous rules of 2017 were struck by the Honorable Supreme Court Constitution Bench in November 2019 in the case called Roger Matthew versus South India Bank. So, in this case, the Supreme Court has struck down the rules of 2017, and in this context, the government has proposed new rules regarding the appointment and service conditions of members to tribunals 2020. However, the lot of people have argued, the critics have argued that the new rules carry out only cosmetic changes and some of the provisions contravene the spirit of law laid down by the Supreme Court in the matters related to the tribunals. Now, let us try to explore the issues with the new rules. Number one is the conflict of interest. The new rules do not remove the control of parent administrative ministries, that is, ministries against which tribunals have to pass orders. So, like the old rules, there is still this issue wherein the control of the parent administrative ministries is still existent over the tribunals. See this scenario. There has been an issue raised against a particular ministry. So, the issue has been taken up to by a tribunal. But what happens is the overall control of this tribunal is under the ministry. So, that is why it could lead to a conflict of interest. For example, the tribunal such as the Armed Forces Tribunal. See, you have a tribunal named as Armed Forces Tribunal, which functions under the same ministry, which is party to the litigation, and the ministry also wields rule-making powers and controls the finances, infrastructure, and the manpower of the tribunal. So, because of this, the independent functioning or the decision making of the tribunals could be very limited, defeating the very purpose of the tribunals. So this is against the very spirit of natural justice, where the litigant as well as the tribunal is under the overall all pervasive control of the parent ministry. Next, rules of diluting judicial independence. The selection committee under the new rules can function even in the absence of any judicial member, meaning that a committee entirely or majorly comprising of officers of the executive can select members of the tribunal. So, what is the issue over here? So this leads to unwarranted influence of the executive. The new rules and also ensure that the secretary of the ministry against which the tribunal is to pass orders sits on the committee for selecting the adjudicating members of the same tribunal. So thus you can see that the system is termed as a mockery of the constitution by the Supreme Court in the Madras Bar Association case of 2014. So the tribunal is supposed to pass orders against the ministry. However, in reality, you have a secretary of the ministry sitting in the tribunal, and also the members of the tribunal are selected by the secretary of the ministry. So obviously there is a conflict of interest. Obviously there is a uh, the the justice which is meted out might not be satiating the litigants. Then it is affecting the independence of the members. The new rules provide for a retirement age of 65 years even for the former judges who retire at 62 years from the high courts, which gives them at best a 3-year tenure. This is against the minimum 5 to 7 years tenure mandated by the Supreme Court in the Union of India versus the R. Gandhi case 2010 to ensure continuity. Further, the bar on employment with the government after retiring from the tribunals has been removed, thus gravely affecting the independence of the members. So, what is happening is if the person who is functioning as a member of the tribunal in future, if he is able to join any other government position, obviously when they pass on a particular judgment which is against the interest of the ministry or the department, there is always a fear that they will not get proper postings in the future. Because of this, the members of the tribunal, while they are functioning, they are not functioning in an autonomous manner. They are not functioning in an independent manner, and thus they will take decisions based out of fear, and obviously that will be against the interest of national justice and against the interest of the litigants to the dispute. Next, the new rules are inconsistent with the Supreme Court rulings. The new rules contain ambiguous clauses stating that any person with experience in economics, commerce, management, industry, and administration can be appointed as a member of certain tribunals. This may allow even members with non judicial as well as legal background to become chairpersons of the tribunal, thus, contrary to the Supreme Court ruling in the R. Gandhi case of 2010. So, having discussed this, now let us try to understand what exactly do you mean by a tribunal. A tribunal, my friends, is a quasi judicial institution that is set up to deal with the problems such as resolving administrative and tax related disputes. See, the major mechanism of judiciary in India is the courts. That is what we call as the judiciary, the various high courts, the Supreme Court, and the lower courts or the subordinate courts. However, as you know, the judiciary presently, owing to the large population of India and owing to the high volume of cases, is unable to absorb the workload, and it has its own limitations. So thus the delivery of justice is being delayed to the citizens. So that is why these tribunals have been provided as an alternative mechanism of justice delivery related to administrative and tax related disputes. So these tribunals perform a number of functions like adjudicating disputes, determining the rights between the contesting parties, making administrative decisions, reviewing an existing administrative decision, and for on so forth. Tribunals were not part of the original constitution. However, it was incorporated in the Indian Constitution by the 42nd Amendment Act of 1976. Also, Article 323A deals with the administrative tribunals. Okay, so please note that the concept of tribunals was introduced in the Indian Constitution by the 42nd Amendment Act of 1976, and Article 323A deals with the administrative tribunals, and Article 323B deals with the tribunals for other related matters of the government departments and ministries. So, what could be the way forward? Having discussed the limitations of the new rules, the author tries to suggest some improvements that could be incorporated so as to make these tribunals function in a more autonomous manner. Number one, maintain the independence of the tribunal. How this should be done? Unless steps are taken in compliance with the law laid down by the Supreme Court for tribunals, neither their independence nor their ability to reduce the burden on the regular judiciary can be guaranteed. So, we have discussed what are the limitations. Because of these limitations, what is happening is the litigation is not being resolved, and thus, in spite of the tribunals being existent, the order passed by the tribunal is then again challenged in the various high courts and also the Supreme Court. Thus, the very purpose of the independence of the tribunals and the purpose of reducing the burden of the judiciary has not been attained because of tribunals. So that's why the author states that there should be an independence which should be catered to the tribunals. So the Supreme Court has already laid down certain norms for that. So the once if the government while framing the rules is following these norms, automatically the independence and autonomy functioning of the tribunals is guaranteed. Number two, separate and independent authority for the administration. The Supreme Court, in the case of L. Chandrakumar, R. Gandhi, and the Madras Bar Association and Swiss Ribbons case of 2019, had ruled that tribunals cannot be made to function under the ministry against which they are to pass orders, and they must be placed under the law ministry instead. So this is one of the suggestions given by the Supreme Court in various cases. Thus the need to ensure the separate and independent authority for administration of the tribunals is required. So now let us try to look at the Income Tax Appellate Tribunal. The Income Tax Appellate Tribunal was created in the year 1941. At the time, it was put under the Finance Department, but later it moved to the Legislative Department under the Ministry of Law and Justice, so as to ensure its independent functioning and autonomous functioning. So this arrangement continues till date and is perhaps the primary reason that is why this income tax tribunal is performing better than most of the other tribunals. Thus, other tribunals can also be made to function under the law ministry rather than their parent ministries against which they are supposed to pass their orders. So this could be one of the suggestion to improve the functioning of the tribunals. Next is the easing pressure on the constitutional courts. Further, in order to remove unnecessary burden on the Supreme Court and make justice affordable and accessible, it needs to be ensured that the tribunals work efficiently. In this context, the high courts, being equally effective constitutional courts, practically should become the last and final court in most litigation after tribunals pass the order. Thus, Supreme Court could be allowed to focus more on constitutional points of law of general public importance, central state interdispute, center and state, as well as interstate disputes, or where there is a major conflict between the decisions of two or more high courts. So the author is stating that the functioning, the litigation related to tribunals can be taken care of by the tribunals themselves, or at max at the high court level, but they should not be percolated into the Supreme Court, because the Supreme Court is already overburdened, and Supreme Court should be looking at more important points of law, more important constitutional points of general public importance. Also, special leave to appeal may be extended only to really special cases. That is, only in most important cases that the appellate jurisdiction of the Supreme Court can be activated regarding the orders of the tribunal. These measures will not only provide consistency and stability, but also promote judicial discipline in the tribunals as well and the whole judicial system. In conclusion, it is the need of the hour that the Union government shows enough force systemic tribunal reforms. So, the author states that the Union government has to show enough will to force systemic tribunal reforms, and a reform to the tribunal system in India may as well be one of the keys to remedy the age old problem that still cripples the Indian judicial system, the problem of judicial delay and backlog. In this context, an independent autonomous body such as the National Tribunals Commission shall be created, which could be responsible for the oversight as well as the administration of the tribunals, and can go a long way in remedying the issues that plague the functioning of the tribunals. So this is one of the suggestion which could be a way forward for the overall improvement in the functioning as well as the efficacy of the tribunals. So here you can see the judicial structure. At the apex of the judiciary in India is the Supreme Court, and then you have various high courts in various states and union territories. Then you have metropolitan courts, that is this at the civil, you have the city civil courts and the courts of small causes, and for the criminal proceedings you have the sessions court, metropolitan courts, and magistrates courts. And at the district level, you have the civil district court, civil judge, that is the senior division and junior division. And for the criminal proceedings, you have the sessions court and the judicial magistrate. And you have various tribunals, namely the Central Administrative Tribunal, Income Tax Appellate Tribunal, Motor Accident Claims Tribunal, Cooperatives Tribunal, Rent Control Tribunal, and the National Green Tribunal. Next, you have the industrial court and the labor courts, as well as the various family courts. So these are the various broad contours of judiciary in India. Apart from this, you have the alternate dispute resolution mechanisms as well. Okay, so now let us try to discuss a mains question which could be asked regarding the functioning of the tribunal and the autonomy of the tribunals. The question states, reform in the tribunal system in India can address the problems that still cripple the Indian judicial system. Comment. So, based on the discussion that we had, please try to understand the question and try to answer accordingly. Okay, so what could be the possible reforms that could be included in the tribunal system, and how tribunals can function as alternatives to the Indian courts, and how justice delivery can be made more accessible and speedy justice can be meted out to the litigants. Thank you. Have a good day.